may come forth and declare it, and they shall be heard.
Good morning. You can be seated. For the moment, we are going to pretend we're actually the First Circuit Court of Appeals. And the first matter in front of us is Scott versus Moody. This is CA number 2342. I see we have a full room. Counsel appear to be present, and I assume are ready to proceed. I would ask counsel for the appellant to begin by introducing yourself, followed by the appellee, and then we'll turn to the arguments. For the appellant.
Chief Justice, Your Honors, Danny Hutchins for appellants.
For appellee.
Chief Justice, Your Honors, Leah Henry for appellee.
Thank you. Counsel, if you're ready to proceed, we'd be happy to hear your argument this morning.
Chief Justice Stanfill, Your Honors, may it please the court. May I please reserve 2 minutes for rebuttal? Thank you.
Yes?
This
You already
case-
did.
This case is about whether elected public officials can flagrantly violate the constitutionally protected free speech rights of their constituents without accountability, simply because they're doing so on the new frontier of social media. Your Honors, this court should reverse the decision of the United States District Court for the District of Massachusetts and hold that the district court erred in granting summary judgment for Chairperson Moody because they incorrectly applied a bright line test and instead should have applied a totality of the circumstances approach. This court should reach this holding for the following 3 reasons. First, a totality of the circumstances approach that examines the purpose and appearance of the page is most consistent with both this court's precedent and that of this court's sister circuits. Additionally, this approach ensures that all First Amendment violations on social media are redressable. Second, applying that test to the facts of this case, Moody engaged in state action because her page has the purpose and appearance of her official role. And third, even applying the bright line test, Chairperson Moody was not entitled to summary judgment because the district court misapplied the test. With that, I welcome this court's questions.
How did the court misapply it?
The district court, in the 2 prongs of the test, an official acts under their official duties if there was an actual duty via statute or an apparent duty. Here, Moody was clearly acting under one of her apparent duties. And a duty of an elected official is to communicate with their constituents. That's a fundamental job that they're elected to do. And in a
Well, is the apparent duty the communication? I mean, all social media, the purpose of it is communication. How does that have to do with what the duty is?
Your Honor, public officials must solicit input from their constituents and remain responsive to them. The Supreme Court in Terra Manello noted that the primary purpose of the First Amendment is to ensure that the government is responsible.
What if the page was 99% cat videos and 1% referenced his government function?
Your Honor, in your hypothetical, then that likely would not be state action.
Okay, now it's 5%.
Here on Joint Appendix page 20, Moody used her page 95% for her school function, wherever the court decided to draw that line.
Well, how do you determine the school function in her role as the chairperson? To the extent that there are pictures of her attending various events around the school. She also has children in the school. I mean, if she has pictures of some type of bake sale, does that constitute her act as an official act as her duty as a chairperson?
Your Honor, that post alone may not constitute her action, but when looking at all the posts together, including the fact that Moody
Well, the post of her attending a school play and saying she thought it was an excellent job, which side of the line does that fall on?
When looking at the page in its entirety, including the fact that Moody uses the page to solicit input, when a constituent scrolls through the page on Twitter and sees the solicitations for input, sees discussions of board policy in addition to those photos that you reference, it gives the appearance that the page is part of her official duties.
Is it significant that she invited everyone to attend a K-12 budget basics webinar?
Yes, Your Honor, that is significant because that is part of her purporting to invite people to attend.
So in the mix, that's a strong point in your favor. But the concern with the holistic approach, the totality of the circumstances, has a certain disturbing mushiness to it. Justice Connors served up some percentages, and obviously there would have been a tipping point at some point. So what happens is Judge A may say, oh, absolutely, state action was, oh, absolutely not state action. And they both will be upheld on appeal. Doesn't that put us in a precarious position where the judge is the gatekeeper to these very important constitutional rights? How can that be?
Your Honor, it's important here to put the burden on the public official to ensure that they are comporting.
A lot of these public officials are voluntary local lay people, and they're not, judicial scholars, and they need to have a kind of a bright line test to know whether they have to abandon the page that they've had for the last 12 years or get some guidance that they can follow. How do we do that when we understand these people are lay people often?
Your Honor, by focusing on the appearance and the purpose of the page, a lay person can look at their page, and if, as here, they use it for 95% to post about the school and to solicit input from their constituents, in addition to at the top.
Counsel, so let me take you up on that point. This page was initially set up as a campaign, as part of her campaign process, correct?
Yes, Your Honor.
And elected officials, once they get elected, they never really stop campaigning, do they? And so when I look at this site, when I look at appendix page 25, I don't see any earmarks of official committee status there. Why is it inappropriate for even an elected official to keep a campaign site going and to inform constituents as to what good work she's doing?
Your Honor, in Campbell v. Reich, the Eighth Circuit noted that a page can transition from being campaign use into one of official duties. Here, there's no evidence in the record where Moody talks about running for re-election or raising money.
Can it transition from an official campaign into simply a personal site? An ongoing campaigning for the next campaign.
Your Honor, following the logic of Campbell, it could transition to a personal page if all the elected official did was then post about their personal life or their job outside of the...
Does that have to be all they do?
No, Your Honor, it would not need to be all they do, but it would have to be at least a majority of what's on the page, so that when a constituent visits the page, by a quick scroll through, it's clear to them that this page is not a page that the public official uses.
You said majority. Does that mean that 50% is the tipping point that Justice Connors was getting at?
Right. Aren't you proposing a bright line test in effect?
No, Your Honor. The 50% may not be the tipping point. The factors would need to be weighed, but again, here, 95%, wherever this court decided is the most appropriate place to draw that line, 95% is certainly sufficient in order to meet whatever standard that this...
Before we start getting into percentages, is there anything in the trajectory of our case law, meaning our First Circuit case law, that would suggest to you that we are headed toward a totality of these circumstances test? Should we be faced with it here?
Yes, Your Honor. In Zambrano-Marrero, in the police context, this court explicitly applies a totality of the circumstances approach when examining police conduct and state action. This court does so because police officers' appearance evokes authority, and police circumstances can be complicated. There's a variety of factors and considerations that can come up, and so this...
So should there be a different test for people who are not police?
Here, Your Honor, a social media page, as the Garnier court found, is similarly in its appearance clothed with the prestige and power of the actor's official duty.
Social media by itself is clothed with that?
Social media pages can be clothed with that.
They aren't necessarily, unlike a police officer in uniform.
Yes, Your Honor. When a police officer wears their uniform, they are asserting their appearance. That's similar here. When a public official writes that they are the chairperson of the school committee and they post about the school, they are, in effect, putting their appearance out to the public as being the chairperson. If it was just personal use, that would not be dissimilar to a police officer who never puts on their uniform, never takes out their badge, and never identifies themselves as a police officer.
So in terms of the guidance that we would be giving public officials who maintain personal social media accounts, in a sentence, what's the rule?
Your Honor, that when they use their page for their official duties and they give it the appearance that they are using so for their official duties, they are engaged in state action.
Does that mean they are exercising their official authority in the post, on the webpage?
Yes, Your Honor, exercising an official or apparent authority. It wouldn't just be duties that are dictated by statute or municipal codes, but also duties that are intrinsic to the office that they
Would it
hold.
make a difference, counsel, if all of the official posts were retweets as opposed to original tweets? In other words, if she just retweeted tweets from the committee's official tweet.
Your Honor, it may make a difference if that is all she did, but here she didn't just retweet the posts. Many of the posts she added her own policy justifications or explanations as to why she voted. That gives it the appearance of her putting forward the justifications and why she was supporting these policies, especially in this context with COVID-19 in schools. It was ever-changing, guidance was changing by the week and by the month, and so...
Do we need
sounds
to
like-
look at this from a post-by-post situation? I mean, let's say she posts some cat videos and she posts some official functions. When she posts a cat video, somebody says something really nasty about her cat. She's allowed to block that, isn't she?
Your Honor, this court should look at the page as a whole, as the...
So she can't block it. That guy, every time she posts a cat video, can say something horrible about her cat?
If the page as a whole is
Depends
for
how you feel
her,
about cats.
is for her official duties, then she may be engaged in...
So your answer is yes.
Yes, Your Honor.
Well, does it make a difference that there's an official school committee Twitter account, and that the information that was going out on her, I'll call it a personal account, but you're going to say it is something else. Does it make a difference that there's a separate account in which all the information that your clients had been submitting with regard to their discontent with the school policies still appears on the official account?
It is true, Your Honor, that there are two pages and the school committee page she jointly maintains. But here, the Scotts did comment on both her page and the school committee page.
And it still appears on the official school committee page, does it not?
It does, Your Honor.
And is there anything in this record to indicate what the viewership is with respect to her page versus the school committee page? Which one gets more views or likes or whatever?
There's no information in the record as to the broad level of engagement on the page.
Should that have some bearing on what standard we apply in the context of this case?
Here, Your Honor, Moody chose to use this page as the page where she engaged with the Scotts. She made the decision to respond to their comments regarding COVID-19 on this page, and then subsequently blocked their posts rather. So
On her page?
On her page.
But not on the official school committee site?
No, she did not on the school committee site. But again, she made the conscious choice. I see my time is up. May I briefly conclude?
You may finish your sentence.
Thank you. She made the choice to engage with them on her page. Therefore, we ask that this court reverse the grant of summary judgment. Thank you, Your Honors.
Thank you.
Thank you.
Attorney Henry?
Chief Justice Stanfill, Your Honors, may it please the court. This case is about an engaged member of the community, volunteering her time to support and advance the school district in which her two young children attend, all while maintaining a Twitter account in her personal capacity as protected by her First Amendment right. Created at the start of her campaign for office, Moody's account stands wholly distinct and separate from the official school committee and school district accounts, and any management of her personal page does not rise to state action. Your Honors, this court should affirm the decision of the United States District Court for the District of Massachusetts for the following 3 reasons. First, the Sixth Circuit's bright line test that the district court applied is appropriately founded in the Supreme Court's nexus test to determine state action and stands directly in line with First Circuit precedent when applied to the social media context. Second, the district court correctly found that Moody was not acting under color of state law when she managed her personal account outside of the official duties of her school committee position and without any official government resources. Finally, even if the district court had utilized the test under which the appellants call for, Moody's activity still could not be held as state action, as she did not pretend or purport to be acting in any official school committee capacity through the appearance or purpose of her personal page. Your Honors, regardless of the test under which Moody's activity is analyzed, the district court correctly found that her actions were not state action, and this court should affirm summary judgment. I welcome this court's questions.
You made your second point, you said, was that the district court found that Ms. Moody was not acting under the color of state law. Did the district court actually make a finding in this case?
Your Honor, it was a question of law, and they did find that her actions did not rise to state action.
So when you say found, you're not talking as a factual matter?
No, Your Honor, it was under.
This is as a matter of law?
That is correct.
It is on summary judgment. So what is the
That is
deference that
correct.
we give to that finding?
It's de novo, Your Honor.
Thank you.
When the chair of the school board opines on matters involving the school district, shouldn't every member of the public have access to the chair's viewpoint on that?
Absolutely, Your Honor. Moody, as the chairperson of the school committee, has a duty to communicate with her constituents, which she faithfully executes on the official school committee page.
But also, she was communicating with someone on her own so-called private page, too, wasn't she?
As a public, yes, Your Honor. As a public official, she has a personal right to engage in her personal capacity as well, outside of your office.
Because she's a public official, I mean, you started off by saying that she used the Twitter account to support and advance the school committee. I mean, isn't the whole point of supporting and advancing the school committee, doesn't that exactly slide over into making it an official account or an official act?
On her personal campaign page, she is purely engaged in activity that is either progressing her campaign goals and showing the constituents that elected her how she is doing in her position, or engaging as any other parent would with the information that she posts.
Is her subjective intent relevant?
Your Honor, her subjective intent would be relevant to whether she is intentionally committing an official duty of her office.
Well, Exhibit 16, she tweets, "You're invited to a K-12 Budget Basics webinar this Thursday. This is an express invitation offered by someone who is in a position of authority, inviting them to come. Isn't that 16 standing alone an exercise of government authority?"
Your Honor, she could have posted that just as well as a campaign matter. Though she has access to that webinar, she's inviting other parents that also have access to that.
But she's inviting them in her capacity as a member of the authoritative group here. You're invited. Who else can invite someone to come to the... She didn't say, oh, there's a big hearing on the budget next week, we all should show up. She's saying, you're invited. I am on the school board, and I am inviting you. Doesn't that land us squarely in the government function?
Your Honor, that verbiage might weigh in favor of finding state action on that specific post. However, the Eighth Circuit in Campbell versus Reich has indicated that sporadic engagement with constituents may be using...
It wasn't sporadic here, was it? I mean, it was pretty consistent.
Your Honor, the posts about the school board were consistent. The appellee does not dispute the fact that 95% of her posts were about the school.
Well, it sounds like you're leaning more to the totality of the circumstances, saying, well, yeah, that one might qualify, but look at it in the context of the totality of the circumstances.
Your Honor, this circuit, this court has found that a totality of the circumstances, to the extent that it comes in, may be appropriate for some instances.
And that's in Zambrana Marrero, right?
That is correct, as well as Martinez
Aren't we
versus...
headed towards that as I said earlier, the trajectory of our jurisprudence is headed towards totality of the circumstances?
Your Honor, this court has shown that while the totality of the circumstances might come in, it's a higher level of analysis, not an alternative test. This court has established that looking at state action still begins with the two-pronged test that this court has established, and the Sixth Circuit mirrors almost exactly.
Well, it doesn't in the context of police officers performing their duties. It's the primary analysis, is it not?
Your Honor, in Zambrana, the two-prong analysis is still part of the state action analysis. It is weighed heavily within the police context, as this court has dealt with state action primarily within police context. The bulk of the analysis falls into totality of circumstances. However,
because
it
of
begins...
the various nuanced events that police can engage in the performance of their duties. And don't you have that same circumstance here in the context of a school committee? A person who's overseeing the process and the policies with respect to the children of the folks in the district that she's responsible for in the context of their education.
Your Honor, as discussed briefly before, police officers are a different class given their appearance can evoke and compel constituents to act in a certain way. There is no comparable...
And you don't think that requiring parents to send their kids to school 2 days a week under a hybrid program in the midst of a pandemic is having the authority to compel certain things to happen?
Your Honor, the page wouldn't be compelling the constituents like the Scotts to act in any certain way. The policies of the school board, certainly, and Moody, as the chairperson, is part of that state action. However, engagement on her personal page does not compel the Scotts to act in any certain way.
Just to take one example, I'm looking at page 30 of the appendix, and this is Exhibit 9 to the Joint Statement of Facts. Holding it up so you can see it.
Yes, thank you, Your Honor.
It's a post from Ms. Moody that says, upcoming school committee meeting, and then there's a notice of the meeting. So she's notifying the public about a school committee meeting that's coming up. Isn't that at the core of what school board, school committees do? Shouldn't that really have been on the school board page or the school district page? Isn't she exercising a public duty in that case?
Significantly, Your Honor, this was originally on the school committee page. Importantly here, reposting is a very visible form of posting on Twitter. Within 9 here, every constituent, including the Scotts, can see that the original post announcing the school committee meeting is from the official school committee page. Her post is amplifying that original school committee post, just as any other parent could do, or she would be compelled to do as...
retweeting or reposting, you're saying, doesn't add anything, and people can do that whether or not they're acting under color of state law?
Yes, Your Honor.
To the average person looking at these posts, the record suggests that 95% of the posts are related to school committee or school business. Shouldn't there be some sort of a disclaimer? Should the person who is hosting a private site make it clear to the public that this is a private site? Should there be some burden on Ms. Moody here?
Your Honor, a disclaimer may very well help resolve issues like this. However, requiring a disclaimer, putting a burden on the public official to have a disclaimer is more appropriately founded in the legislature's purview.
If this is treated as a private site, and let's say the evidence shows that she only blocks people who are Black or Arab or Jews, do you think that's a problem?
That is certainly a problem.
Is it illegal? Can she do that because it's private? It's not, even though she's talking only, here I am, an official, now I get to block you because I don't like your minority or your race or your religion. Can she do that?
If that was the case, that would fall under an additional factor. Again, more factors
Well,
might
why?
be appropriate.
Now you're talking content, that, I mean, whether she blocks, but how does that have to do with whether or not she's a state actor?
Starting with the two-prong, if it was found that there was no official duty or no authority on the page, the hypothetical would likely land outside of the purview of state action. If either one of those were more on the fence, an additional layer, given the seriousness of the alleged conduct, would likely come in as a higher level of analysis.
If we were not in the virtual space, but we were in the real world, and she decided to invite people over to her house for a discussion, but she only wanted people, she excluded people who disagreed with her, let's say. She had some sense of who they were, but she kept some people out. Would she be entitled to do that?
Yes, Your Honor. As a campaign actor, she is entitled to.
Well, she's acting as a public official.
Well, if it was within her campaigning role, she would be able to. If she is acting as an agent of the school committee in her chairperson role, then no. However, within their campaign function, public officials hold the right to engage in their personal capacity just as anyone else not holding office does.
If you were to write the holding for the court the way you think it should be, would you simply lift the language from the Sixth Circuit, or is there something more nuanced? I'm inviting you to give us the language you think we should arrive at.
I would lift it first from the First Circuit's precedent, which mirrors the Sixth Circuit. A public official on their social media account acts under color of state law if their actions are an official duty of their office or they use the authority of their office to act.
How about this for a bright line rule? If 95% of the posts on an account relate to the official capacity, it's a state action. How's that?
Your Honor, I actually think the appellants and I agree that turning state action on percentages erases the real central question of what state action is, going to duty or authority.
Well, let me ask you that, though. By talking about the authority, aren't we back doing that a little bit circular in the sense of whether it's actual authority or apparent authority, if it appears to be authority?
Your Honor, when circuits have looked at this through the authority lens, it's often regarding the resources that the office might give to the actor or the real entwinement and control between the office and the actor.
So you're talking about actual delegation of authority from the office as opposed to appearance of authority?
Yes, correct.
Because certainly in the police officer context, for example, the donning of a uniform, whether or not the person is acting within the scope of their authority, gives the appearance of that authority, correct?
Yes, correct.
And so you're saying appearance doesn't matter, it really is whether they're actually using the authority of the office?
Centralizing the state action determination on those two prongs that includes authority is the first level of analysis. For heightened levels of analysis, appearance may come in. Here, Moody did not pretend or purport to be acting in any official capacity through the appearance. And what's difficult with the Ninth Circuit's appearance-only test is that a reasonable person could view her page, maybe as the Scotts did, as a state action account, or more likely, or just as likely, they could see it as a campaign page or a personal page, expressing her views in her personal pursuit.
So if we adopt the totality of the circumstances standard, I'll take you up on your offer. Why would you win?
Because, Your Honor, this account was created as a campaign account, maintained as a campaign account, and is progressed as a personal page. Nowhere in the record does Moody's campaign account transform to a state action page, and thus the appearance of the page does not show her acting in a state action function. Outside of the duties of her chairperson office, Moody maintains a personal account. I see my time is expired.
You couldn't see the timer.
Thank you. Thank you, Your Honor.
We could see the timer, so we knew you had about 1 second left. Thank you. And Mr. Hutchins, you wish to be heard in rebuttal?
Yes, Your Honor. Chief Justice, Your Honors, one brief point on rebuttal. When looking at this page, this court should look at pages from the perspective of a reasonable constituent. As Justice Douglas pointed out, it is very possible that a constituent who visits this page, sees 95% of the posts being about school business, would believe this page to be that of Chairperson Moody's official role.
What if there's a disclaimer? Can that do it? Can that be a black and white test?
Your Honor, you mean if there's like a disclaimer?
This is my private site. It's not part of my official duties.
Go ahead and comment on my cat videos.
Yes, Your Honor, because at the moment the constituent visits that page, there would be this disclaimer so that when the constituent scrolls down the page, they know that this page is personal. That's a common practice on Twitter and social media pages. Here, there is no disclaimer. At the very top, she lists her official school duty. So therefore, because the appearance evokes her authority, and a reasonable constituent would see it as thus, this court should reverse the grant of summary.
So all Ms. Moody needs to do is to put a disclaimer on her page and everything is fine? It's not state action?
That would be a factor weighing strongly against state action, Your Honor. If all there was a disclaimer and the rest of it was like very strong state use, announcing policy, firing officials, then perhaps not, but that would be a strong indicator that the page is used for personal use. Thank you, Your Honors.
Thank you. Thank you, counsel, for your arguments in this case. In the usual situation, we would take the matter under advisement and issue a written decision in due course, but we're not going to do that. Instead, thank you, really, for all of the arguments. It's rather a full house. I'm not sure I've ever seen this many people in this courtroom. But I'm going to invite my colleagues if they have anything to say.
Major kudos to everybody. Excellent arguments, excellent briefs. You've done a great job. Also want to compliment some players I see in the audience here, your teachers in writings and advocacy, and you're nodding your heads. You owe a debt of gratitude for them for your excellent preparation. Well done.
We obviously did our very best to throw you off. But neither of you was dislodged from the point that you were trying to make, and you kept circling back to what you wanted to say, which is the highlight of effective advocacy. So I echo the comments. Great job on both sides.
Let me ask, even though it's past the time to ask questions, let me ask, how many times were you mooted? Did you find that they were helpful?
Yes.
Yes. You don't have to say it.
Were we tougher or your mooters were tougher?
I would say you're tougher.
Yeah.
Did we ask any questions that you didn't hear in your mooting?
Yeah, a number, I would say. The disclaimer is an interesting question, and the two cases that we relied on just went up for oral argument in front of the Supreme Court, and the disclaimer was a major question from the other justices. So we didn't really get that.
Yeah, none of that.
Yeah.
Rick?
I just want to echo the congratulations. I thought you were both poised, prepared, and impressive. So I commend you both. Great job.
And I just want to echo those sentiments. I did my best to sort of ask scatterbrained questions and just went right through them nonetheless.
Thank you.
Yeah, what you saw is actually very real. This court is frequently equally as active as they were with you in real arguments. And welcome it, because that is a clue as to what we might find important when we ask questions. Today, we had the luxury of knowing we don't actually have to decide it, so maybe our questions weren't quite so pointed. But in real arguments, it can feel like you're getting derailed from what you thought you wanted to say. Welcome it, because what the court is doing is they're telling you what is important to us and what we need to hear about. So that's the approach, is always welcome those questions that may be from left field or something like that, because it gives you the opportunity to make your case and to address what the court is telling you they might be finding important, which might be different from what you thought was important. So well done.
Thank you.
This is always a highlight of our year, to be able to do this and to welcome everybody into our space. So thank you. I know there's a lot of faculty and students here, so I'm not going to recognize everybody, but we appreciate all of the preparation and hard work, and it's really a joy to have you here. So thank you.
Thank you
Your
so
Honor.
much.
Appreciate it.
All right.